As to the very question that is relating the conditions for grant of writ of quo warranto, so among those conditions, the first one, the office must be a public office, and it was decided in the leading case Anand Bihari versus Rams Sahai in 1952 by the Madras High Court. The court held that a public office is one which is created by the Constitution or a statute, and the duties of which must be such in which public is interested. In this case, it was held that the office of the Speaker of Legislative Assembly is a public office also. In the leading case, G.D. Kharkare versus Saredi in 1952, the Nagpur High Court held that the office of Advocate General is a public office. In the same manner, the office of the members of a municipal board or the office of a university official or public officers. If the office is not a public office, the writ will not be issued. Therefore, quo warranto would not be issued against the managing committee of a private school, as it was decided by the Calcutta High Court in the leading case Amarendra versus Narendra Basu, or against a member of working committee of such Arya Samaj Pratinidhi Sabha, as it was decided by the Patna High Court in 1954 in the leading case Jamalpur Arya Samaj versus D. Ram. So, the second ground, public office must be substantive in nature. A substantive office is one which is permanent in character and is not terminable at will. So, also, the person must be in actual possession of the office. Mere declaration that a person is elected to an office or mere appointment to a particular office is not sufficient for the issue of quo warranto unless such person actually accepts such office, as it was decided in the leading case Puran Lal versus P.C. Ghosh in 1970 by the Calcutta High Court. And regarding the next one, the office must be held in contravention of law. There must be a clear violation of law in the appointment of a person to the public office. If there is mere irregularity, quo warranto will not lie, as it was decided in the state of Assam versus Ranga Muhammad in 1967. The Supreme Court found the transfer and posting of two district judges contrary to law, but did not issue quo warranto, as it was a case of mere irregularity that did not make the occupation of office wrongful. So, quo warranto will also be issued when a person validly occupies the office but acquires a disqualification later on. So, under what grounds it can be refused. So such condition regarding refusal of issue of quo warranto or in cases of offence of private nature, the writ will not lie, as it was decided in Jamalpur Arya Samaj Sabha versus D. Ram. The High Court of Bihar refused to issue the writ of quo warranto against the members of the Working Committee of Bihar Raj Arya Samaj Pratinidhi Sabha, a private religious association. In the same way, the writ was refused in respect of office of a master of a hospital and free school, which were institutions of private charitable foundation, and the right of appointment to office therein was vested in governors who were private and not public functionaries. So also it will not lie for the same person with some reasons against the office of a surgeon or physician of a hospital founded by private person, as it was decided in the leading case Amarendra Chandra versus Narendra in 1950. Similarly, the membership of the managing committee of a private school is not an office of public nature. Therefore, writ of quo warranto will not lie. And in the leading case, Niranjan Kumar Goenka versus the University of Bihar, Muzaffarpur in 1973, the Patna High Court held that the writ in the nature of quo warranto cannot be issued against a person not holding a public office. So, when the office is abolished on information in the nature of quo warranto will not lie, where a writ was sought to restrain the Chief Minister of Andhra Pradesh from participation in a film on the ground that he was prohibited to do so in view of the codes of conduct for ministers evolved by the union and state in question, and also on the ground that there are certain implied limitations in the constitution upon the conduct of high dignitary like a chief minister, and they must be developed and enforced to shape the democratic values, and also on the ground that he was obliged to devote all his time to his official work as he was a public servant, and further on the ground that he had incurred electoral disqualification. The writ could not be issued as the codes of conduct were not enforceable, and it was not for the court to develop a code of conduct for ministers, and no disqualification was incurred. In such circumstance, issue of quo warranto is not warranted, as it was decided in the leading case B.H. Babu versus N.T. Rama Rao in 1990 by the Andhra Pradesh High Court. So, regarding the very writ of quo warranto, we have discussed the very conditions for granting a writ of quo warranto by the court, also the grounds where it could be refused. So, almost all the relevant cases relating to grant a writ of mandamus and regarding the very refusal to admit a writ of mandamus and all those relevant leading cases we have discussed in the context of those decisions delivered by the various high courts and the apex court or the Supreme Court of India. So, in our upcoming video, we will discuss regarding the very privileges of administration should touch us liability of the government, contractual liability of the government also regarding administrative tribunals.